This video will help you prepare for a deposition in Arizona state workers' compensation claims. First, you need to know what a deposition is. Generally, a deposition is a process where you answer questions under oath. Depositions are a very important part of the discovery process in a legal case, and they can be stressful. You should not take it lightly. Submitting to a deposition is not an option. It is mandatory if you wish to pursue your claim. Usually, the deposition takes place at the office of the attorney who is representing your employer and the workers' compensation insurance carrier. We refer to that attorney as a defense attorney or opposing counsel. Once you sit down, you will be sworn in by a court reporter, and the defense attorney will begin asking you questions. If you are represented by an attorney, your attorney will be with you, and your attorney may also ask questions if clarification is necessary. Once you and your attorney arrive at the deposition, you should expect to see at least 4 people. You, your attorney, the defense attorney, and the court reporter who will be writing everything down. Notice I did not say judge. That is because the deposition is not the same thing as your hearing. It is considered informal and is primarily for the purpose of allowing the employer and the insurance company's attorney to prepare and defend his client. On occasion, you may also see an employee representative or a labor market expert, depending on the issues in your case. You should follow some basic rules in order to keep the written transcript of the deposition clear. Because everything will be written down by a court reporter, it is important not to interrupt each other. You must also make sure that you understand the question being asked before answering. If you answer a question, the attorney will believe that you understood the question. Therefore, if you do not understand a word that was used, you don't hear what was said, or you just need general clarification about the question being asked, make sure that you ask for the questions to be repeated or clarified. Because everything is being written down, your answers must be audible. If you are using a translator, then you must make sure you give the translator time to translate what you are saying. Only the translator's words will go on the record. Shakes or nods of the head will not go on the record because they cannot be written down. Do not mumble. Do not think out loud, or the court reporter is going to have to try to write down every little thing you say. Do not interrupt the person speaking, and do not speak over anyone else. The court reporter can only take down the testimony of one person at a time. Therefore, you need to keep the record clean and clear so there is no misunderstanding later due to lost testimony that could not get onto the record. You need to answer with purpose and intent. Most importantly, your answers are under oath, and therefore they must be truthful. One thing people come to my office saying before a deposition is that they know they need to say as little as possible. That's only true to an extent. The most important thing is that your answers are clear, concise, and directed only to the question that's being asked. You should not volunteer extra information. Also, if you believe you need clarification in order to give an answer, you need to ask the defense attorney to do that. He will give you the courtesy of allowing you to speak without interruption. A deposition, though informal, can still be intimidating. Try not to be intimidated by the opposing attorney. They're people too. On the other hand, if the opposing attorney is very friendly, remember that he or she is not your friend. Nothing is off the record at a deposition. If you are inconsistent or you give false information, even unintentionally, it can be used against you later. What you say at the deposition needs to be the same thing that you say at the hearing, the same thing you say to the doctors or anyone else in the case. Consistency is key. Be professional and be polite. The defense attorney is evaluating you and your ability to answer a question. Look at him or her in the eye. Even if a question or a topic makes you uncomfortable, sad, or angry, it is important to maintain your cool. If you do not know the answer to a question, say you do not know. If you don't remember, say you don't remember. Both of those answers are perfectly acceptable. If you think you remember, but you are not sure, use the words, I think, I am not sure. Remember that the court reporter cannot take down your tone of voice. For example, if the question is, when did you have knee surgery? And you're not sure of the answer, but you think it was in 1995, don't say 1995. ending your answer in a question. You do not need to say it like that. You need to say, I think it was 1995, but I am not sure. Do not feel pressured to answer a question you do not understand or you did not hear. Do not rush your answers just because the questions may be coming quickly. Feel free to count to 3 before answering in order to force yourself to slow down and really make sure you understand the question. Answer all the questions from your personal knowledge. Don't guess. Don't speculate. Your answer should be in your own words. Do not allow the opposing attorney to put words into your mouth. Sometimes attorneys try to summarize what you're saying by asking if you agree with their summary. Only agree if the summary is exactly correct and true in all respects. Do not allow the opposing attorney to interrupt you while you're giving your answer or to move on until you have completely finished answering the question to your satisfaction. You do not need to bring anything with you to the deposition other than yourself, a drink, and maybe a cough drop if you think you might need it. Do not bring your documents or any letters from your attorney. If you disclose a document during a deposition, you will have to show it, and then it's no longer privileged. If you need to refer to something like a business card that you might have in your wallet, you should discuss it with your attorney first. You should also not offer anything to the defense attorney like information or documents that you think you have at home, unless you discuss it with your attorney first. If you need a break or you have a question for your attorney, you should advise the defense attorney and then finish answering the question that has already been asked. You will be permitted to speak with your attorney or have a break if you need one.